customs union or economic union, free trade area, or similar international agreement. And the questions related to taxation, because states consider that these questions regarding taxation are to be governed by double taxation treaties and not bilateral investment treaties. Okay? So we can find those exceptions in almost every single bilateral investment treaty. And it's very common to see those exceptions when a treaty includes the most favored nation treatment, such as in the realm of the World Trade Organization, as we have mentioned yesterday. So some other international investment treaties, bilateral investment treaties, include some more specific exceptions to the most favored nation treatment. We can mention this example. It's a free trade agreement between the People's Republic of China and Peru, concluded in 2009, and Article 31 states that each party shall afford to investors to the other party treatment no less favorable than that of course in like circumstances to investors of any third state with respect to the establishment, acquisition, etc., etc. So this is a pre-admission model, pre-establishment model. This is the most favored nation treatment, so between China and Peru, means that China has to grant to Peruvian investors in China the best treatment China is granting to any other foreign investor, and reciprocally, Peru has to grant the best, to grant to Chinese investors in Peru the best treatment that it grants to any other foreign investor. So that's very classical formulation of the most favored nation treatment. But we have here an exception to this provision. Notwithstanding paragraphs 1 and 2, the parties reserve the right to have or maintain any measure that accords differential treatment, in that you have the right to discriminate to socially or economically disadvantaged minorities and ethnic groups, or be involving cultural industries related to the production of books, magazines, periodical publications, or printed or electronic newspapers, and music scores. So here we have some more specific exceptions to the most favored nation treatment, and for this one, it's mostly an exception to the national treatment, stating that the state, and in that case, it's a provision influenced by the environment in Peru. Well, in Peru, the power has been used against some minorities, and has the authorities have evolved on that subject. Now, the authorities of Peru try to advantage minorities. So it means that the Peruvian government can adopt a legal regime in favor of minorities, and of course, a foreign investor cannot claim the benefit of that favorable treatment. And the second one, which is quite specific, means that the state, China or Peru, has the right to discriminate between investors, between national and foreign investor, or between two foreign investors in the cultural industries related to the production of books, magazines, etc. So in that case, for this specific economic sector, or this specific sector of the economy, the state, China or Peru or both, have the right to discriminate and is not bound by the most favored nation treatment. Okay? So we've seen that the most favored nation clause or the most favored nation treatment has a wide scope of application, but there are of course some exceptions. But we'll now deal with some more specific issues regarding the implementation of the most favored nation treatment. Do you think that we can import a provision that is absent from the treaty by using the most favored nation treatment? I'll give you an example. If you have a treaty between A and B, okay, state A and state B, with a provision including the most favored nation treatment. Let's say that in that treaty there is no provision regarding what we call the fair and equitable treatment. Okay? But do you know what is the fair and equitable treatment, which is the most basic principle, the most basic standard in the field of the international law of investment? Have you ever heard of this fair and equitable treatment?
Government must treat the investor fairly.
Yeah, and what does it mean, treat?
Discrimination. It means that when they offer some incentive, they have to offer all sector, all investors.
That's not exactly what you say. What you say is, so it's a non-discriminatory treatment. Okay. Non-discriminatory treatment. But this refers mostly to the national treatment and the most favored nation treatment. We don't have the right to discriminate between the national investor and foreign investor, and we don't have the right to discriminate between two foreign investors. So the fair and equitable treatment does not involve the non-discriminatory treatment. But of course, with that the government has to treat the foreign investor fairly and in an equitable way. What does it mean, fair and equitable treatment? What could it mean if it's not a question of discrimination? What could it be? Because, I will give you one example.
Maybe regarding the investment requirement, like the requirement in order to invest in some sector.
So, what does it mean? Can you give an example?
For example, like the process of register the company.
Yeah.
In that country must be treated fairly between local and foreign investors.
That's the national treatment.
That's the national.
Yeah. So, so fair and equitable treatment. Of course, we could expect fairness from the government towards national and foreign investors. But fair and equitable treatment is the standard that the state has to respect in any circumstances every circumstances. It means that, let's say that a state, well, in case of expropriation, okay, expropriation, did you know what it means? Expropriation. Okay. So in case of expropriation, let's say that the domestic law said that there is no compensation, okay, no indemnity. Okay. So if domestic law states that in case of expropriation there is no obligation for the state to give some money to the expropriated investor. The state will say, well, I don't have to compensate the expropriation or to give some money, some indemnity to the foreign investor, because in my domestic law, I don't have to compensate, to give some money to give compensation to the expropriated investor. So the national, even if you enforce, even if you apply the national treatment, the foreign investor may be in a situation not to receive some money from the state who decided to expropriate the investor. So in that case, the investor will rely on fair and equitable treatment, which means that there are basic obligations binding on the state that the state has to respect, that the state has to commit with, even if domestic law is less protective than that standard. Okay, so fair and equitable treatment is what we call sometimes the minimum standard. Okay, so the state cannot say, well, in my domestic law, I don't have this kind of obligation, so the state cannot behind the national treatment, saying, well, I don't have to give this to foreign investors because I don't give the same thing to domestic investors. So fair and equitable treatment is the minimum standard, what every single investor can expect from state. Okay. So most of the time, you have the provision in the treaties regarding the investment that include the fair and equitable treatment. Okay, most of the time. But let's say that, well, fair and equitable treatment is the right to be protected against the denial of justice. Means that you have the right to access to the judge, to the justice. So protection against the denial. It's okay, denial of justice. Okay, it's the right to be protected against arbitrary decisions, etc. Okay, so it's really the minimum standard, the basic obligations binding on every single state.
And where is the basic standard come from? You mean from the content of the treaty?
Well, most of the time in the treaty you have some. We have it. Okay. Yeah. Investments and activities associated with investments of investors of either contracting party shall be afforded fair and equitable treatment and shall enjoy protection in the territory of the other contracting party. So, in most of the bilateral investment treaties, such as the Colombia-China Bilateral Investment Treaty, you have a provision on the fair and equitable treatment. Okay, but what the fair and equitable treatment is made of? What does it mean to be treated fairly and in an equitable way? This has been interpreted by tribunals. Okay, so arbitral tribunals will say very oftenly that, well, to benefit or to grant a fair and equitable treatment, it means not to adopt some arbitrary decisions towards a foreign investor. It means that you have to protect the investor from the denial of justice. Means that the investor, the foreign investor, has the right to claim something before a domestic court if that investor wants to claim something before a domestic court. And of course, the domestic court has to be independent, non-partial, etc., etc. So that's in 99% of the bilateral investment treaties you have provision regarding the fair and equitable treatment. Okay, so if we have a treaty between A and B with the most favored nation treatment, but no provision regarding the fair and equitable treatment, do you think that, let's say, an investor, national of A, on the territory of B, could claim the benefit of the fair and equitable treatment with the most favored nation treatment included in the treaty between B and C? If in that treaty you have the fair and equitable treatment. So, can you claim by way of the most favored nation treatment the benefit of a provision which is totally absent of what we call the basic treaty, so the treaty that is applicable to the situation of investor A in the territory of state B. So,
Maybe no.
sorry?
Maybe no.
Maybe why? Maybe not why?
Because it is not stipulated in the treaty that investor of a country should enjoy the fair and equitable treatment
Yes.
from the treaty.
Yeah, but can't we consider that the fair and equitable treatment in treaty between B and C is a better treatment given by B to investors coming from C, investing on the territory of B. And the purpose of the most favored nation treatment, the purpose of the most favored nation clause, is to extend the benefits of the most favorable treatment given by one state to, in that case, to foreign investors in like circumstances, etc., etc. bilateral investment treaty between B and C. Okay, so here you have the same state. Okay, if there is, let's say in Article 5 of that treaty between B and C, a provision that includes the fair and equitable treatment. It means that B has to respect the fair and equitable treatment towards the investors from C on the territory of B. Okay, but in that case, investor from A on the territory of B cannot claim directly the benefit of the fair and equitable treatment, because the fair and equitable treatment is not mentioned, is not included in the treaty between A and B. But we have the most favored nation treatment in that treaty. It means that B is under the obligation to give to or to grant to investors from A the best treatment, the best treatment B grants to any other foreign investor, including the investors from C, right? So, if you have this kind of situation, the arbitral tribunals decided that the investor from A can claim the benefit of fair and equitable treatment included in Article 5 of Treaty between B and C because of the most favored nation treatment. Because B is under the obligation to extend to A and to extend to investors from A the best treatment B accords or gives to foreign investors in like circumstances. So here, to investors from C on the territory of B. Okay? So even if there is nothing on the fair and equitable treatment in treaty A-B, an investor from A can claim the benefit of a provision of treaty between B and C because of most favored nation treatment. Okay? So that's the situation. This is what declared an arbitral tribunal in an award in 2005 in the Bayonder versus Pakistan case. Okay? So there was no reference to fair and equitable treatment in the bilateral investment treaty between Turkey and Pakistan, but Pakistan has included treaties with other states which include the fair and equitable treatment. So Pakistan is under the obligation to grant to Turkish investors, such as Bayonder, to grant to Turkish investors the benefits of the fair and equitable treatment. Okay? Fair and equitable treatment. The question is, what could be the limits of this? How could we limit this application of provisions of that treaty to investors of that state, which is of course not party to that treaty? We can mention this case. So this is an attempt by the tribunal to limit the recourse to the most favored nation treatment. So TechMed versus Mexico. in that case, so matters relating to the application of the time of the agreement, which involve more the time dimension of application of its substantive provisions rather than matters of procedure or jurisdiction, due to their significance and importance, go to the core of matters that must be deemed to be specifically negotiated by the contracting parties. These are determining factors for their acceptance of the agreement, as they are directly linked to the identification of a substantive protection regime applicable to the foreign investor and particularly to the general national or international legal context within which such regime operates, as well as to the access of the foreign investor to substantive provisions of such regime. Their application cannot therefore be impaired by the principle contained in the most favored nation clause. So the tribunal says here that there are some principles that cannot be impaired by the principle contained in the most favored nation clause. And in that case, the question was this one. If you have a treaty applicable between TechMed and Mexico was only applicable to investments made after the entry into force of the treaty. Okay. So, in the investment treaty between, well, it's not a NAFTA case, I don't know why this is written. Take maybe the Spanish company, so it's not a NAFTA case. So in that case, so you have a treaty between Spain and Mexico, and the investment. The treaty states clearly that it is only applicable to investments made after the entry into force of the treaty. The TechMed, so from Spain, has made its investment in Mexico, in the territory of Mexico, before the entry into force of the treaty. So, of course, the treaty is not applicable to that investment. So TechMed cannot claim the benefit of the protection of the treaty because the investment was not made after the entry into force of the treaty. But in that treaty between Spain and Mexico, there is the most favored nation treatment, and TechMed tried to use the most favored nation treatment, saying that Mexico has concluded some treaty with other states, we don't care, and these treaties are applicable to investments made before or after the entry into force of the treaty. Okay? So Mexico has concluded some treaties with states, with other states other than Spain, and in those treaties it's mentioned that those treaties are applicable to investments made before